Okay.
What? Oh, no, she is not going to sit there and mouth me. Her bond now is 25,000.
Really?
10%. Yeah, really. You want to?
Hold up. Did she just mouth off at the judge? Oh, that's never a good idea. In court, your words can cost you, but your attitude might cost even more.
Keep going?
Marie Berkshire.
Judge, today's PCC, we're asking this matter for a preliminary exam. And
Discovery is complete.
Yes, Your Honor. I met with her at the jail last night. We went over the police report. I would ask if we could address bond.
I have a tether violation.
Judge, the only thing is, speaking with my client last night at the jail, is the violation is that she couldn't power up the tether. She's still wearing it. And she was released originally on PR bond with the tether. She had problems charging it, and I believe that's the violation itself. We're asking if the court would please consider just to really restore back the PR bond. I would ask for without the tether, but if it has to be the tether, if somebody could look at it, she's still wearing it.
Okay, so let's unpack this. She's wearing the tether, but it's not working. That's like saying, I have the smoke alarm. I just didn't put batteries in it. The court doesn't want excuses. They want compliance.
Doesn't work, so we just need to get that straightened out. For my client, the tether was acting up when she was brought into the jail, so I don't. Okay. I just think the tether people have to either come and adjust it or get a new tether, or hopefully without a tether.
Did she contact the company when the alarm was going off?
Your Honor, I did, but my problem was I couldn't see very well because my contacts, and I accidentally typed in 8100 instead of 8160, and my dad looked at it and we both double checked, and he couldn't see it. He put the wrong one, but I did leave 2 messages for Brian Levitt. He told me to charge it for 20 minutes. We agreed on 20, I did 35. I called them after to see what my percentage was. I left them a message. And when it was going off, I called them again, left a message. When it was going off, me and my dad both attempted to call. And my phone was dead, so I couldn't get his number. But
I don't have any of that information regarding any call to community correction or anything along those lines.
So I had the opportunity to read the community corrections violation report that I believe Your Honor has as well. And that's not what sort of community corrections violation.
I don't, hang on. I have the sheriff's office report.
I have a bond violation.
I do not have that.
Which I don't have. I don't know what it says, Your Honor, but I'm just asking if the court would please consider a lot.
Well, I got to figure out.
Mr. Levitt, and I can provide the court. Do you want me to email this over?
Yes, when you get a chance, that'd be great.
Yes, Mr. Levitt gave her very specific instructions. She was advised to charge it immediately after meeting community corrections, and she was told to, I'm still speaking, she was told to charge it for 2 hours. Mr. Levitt is the person that had to make contact with her while he was sending, he got an alert that the device had low battery. He attempted to contact her on the number that she provided him. That was unsuccessful. He started sending alarms and sirens repeatedly to the advice. Finally, the defendant, finally, I should say, is, I'm really bad at math, 6 hours later, the defendant calls from a different phone number. He goes over the instructions with her again and says, I instructed them to charge it for 2 hours. She said she could not charge it for 2 hours. I told her it was her responsibility to keep the device charged and that it was critically low. And that's, excuse me, if it gets critically low, dispatch will be contacted. They acknowledged this and the phone call ended. They then only charged it for 30.
Yikes. The officer gave clear instructions. Charge it for 2 hours. She gave it 35 minutes. That's like showing up to probation with half your homework done and expecting a gold star.
So she was given very clear directions on what to do. That was from June 10th, the first time it being low at 1 a.m. Then June 10th, 7:47 p.m., we received another low battery alert for the defendant. All attempts to use the defendant were unsuccessful. At 7:48, Indiana Washington County Dispatch was contacted, advised of the violation, and was asked to have an officer respond to take the defendant into custody. By Deputy Mace, who was on scene with the defendant. They were claiming they had been trying to charge the device and were unable. Deputy Mace was told they needed to be arrested on the violation. The defendant had only charged for a total of 45 minutes in the last 5 days. At 9:05 p.m., the defendant was tracking at the Washington County Jail. So the device is clean. In addition to this, my office just charged her with stalking in a separate case. In addition to this, my office requested a $10,000 cash surety bond.
And here comes a twist. She's also been hit with a brand new charge. You know you're in deep when the prosecutor has to switch gears mid-hearing to update your criminal resume.
I'm charging this case. This case being today's case, we requested the $10,000 cash surety on quitting sheets before Your Honor.
Mr. Kirwald?
I'm keeping the same argument, Your Honor. I'm asking.
Okay. Motion for bond reductions denied. Bond rule in here. This matter is revoked.
Judge, it's clarification. Is the bond, what are you, $2,000, 10%?
What do you have this on?
No.
I have 2,010% on this case.
And if she's released, it's on tether?
It's on Tether. She'll have the same conditions.
Okay.
What? Oh, no, she is not going to sit there and mouth me. Her bond now is 25,000.
Really?
10%. Yeah, really? You want to keep going? I didn't think so. Have a good day.
Good morning, Ms. Gonzalez.
Good morning.
Ma'am,
Your new case, new chaos. Miss Gonzalez is up next, and she's facing a Class A misdemeanor for threats against a family member. That's one way to turn a sibling rivalry into a legal nightmare.
terroristic threat of a family or a household member. That takes it up to a Class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on March 20th, 2024 in Harris County, Texas, officers responded to a terroristic threat call. The complaining witness and the defendant are sisters, and complaining witness say the defendant is not allowed to go into a residence. The complaining witness's son mistakenly let the defendant and her husband in, and they drank the beer. The complaining witness texted the defendant about her being in the residence. The defendant responded with threatening messages that said the defendant will slap CW and show up at slap the complaining witness and show up at the complaining witness's job. The complaining witness stated she feared for her safety.
What the hell does that mean? It's got to be serious bodily injury, man. Or
Yes, Judge.
are we putting everybody in jail now for whatever?
Judge, that's really all I have.
Statute. Okay, what was it said exactly again?
Judge, the message that the defendant sent to complaining witness states exactly, bitch, don't talk out your ass because I will go to your house and slap you in front of your family. I'll even come to your job.
That's not imminent serious bodily injury. Come on. All right, I'm gonna find no probable cause, ma'am. As the old adage says, sticks and stones, right? Words.
This judge just dropped the classic sticks and stones. But let's be real. Words can get you arrested if they're seen as threats. In this case, though, the judge wasn't buying it. We'll